Ready for the dictation? Start. It is submitted by learned counsel for the petitioner that it has decided to take the respondent's workmen on daily wage basis as per the office order dated 7/4/2015 and list contained therein. Stop. Needless to say, the names of the respondents' workmen are included in the list contained in Office Order dated 7/4/2015, which has been filed before this court. Stop. Learned counsel for the respondents submitted that as the names of the respondents' workmen are included in the list as per the aforesaid office order, they have no grievance. Stop. Recording such concession, the special leave petitions stand disposed of. Stop. There shall be no order as to costs. Stop. Earlier contempt petitions filed before this court alleging non-compliance of the said order were disposed of on 11/1/2017 in view of the fact that the name of respondent's workman has already been included in the seniority list. Stop. The background leading to the present contempt petitions is that UP Jal Nigam Construction Division Jal Nigam in short has engaged workmen in the category of runner, beldar and lab assistants prior to 1991. Stop. The services of the workmen engaged or appointed after 31/3/1989 were retrenched on 22nd June 1991 or so in terms of Section 6N of the UP Industrial Disputes Act 1947 (Act in short). Stop. The writ petition number 5686 of 1991 challenging such order of termination was decided on 5/11/2009 when the following order was passed. Stop. Petitioners were engaged as daily wager in the UP Jal Nigam sometime in the year 1989 on various dates facing retrenchment of their services. In pursuance to decision taken by the board, UP Jal Nigam took a decision and had issued a circular that all the persons appointed after 31/8/1989 shall be retrenched after serving a month notice and payment of salary. Stop. Accordingly, in pursuance to decision taken by the board, petitioners' services have been terminated after payment of 1 month salary. Stop. Cut-off date fixed by the Jal Nigam has been impugned in the present writ petition. Stop. In a recent judgment reported in JT 2009 (9 SC 229 A. Manju and others versus the MD Women Finance Corporation Limited, their Lordship of Honorable Supreme Court held that ordinarily fixing of cut-off date cannot be held arbitrary unless it suffers from want of jurisdiction or violative of certain statutory provisions or constitutional mandate. Stop.